who makes laws in India? It is certainly not the judiciary, it is the parliament that is elected. But the courts say any law can be scrutinized by them and their word is final. Meanwhile, Vice President also made a statement in his maiden speech as Rajya Sabha chair against the striking down of the NJAC bill. But Law Minister has come out and said that there is no plan to bring a similar bill again. So will the government back down or will it push through a reform here? And will the courts play ball? We will take those questions to our guests in just a bit, but first let me also explain the entire row and the system in question. So first take a look at how this row has come to this pass this year. On October 28, 2022, the Law Minister had spoken to CNN News 18 saying that the NJAC was a better option. He had gone on to say that the collegium system is opaque and that's its broader criticism. On November 11, the Supreme Court issued a notice to the government after delay in collegium recommendations, which is the recommendations that they had given to the government on Supreme Court appointments, etc. Ex-CJI had also told CNN News 18 that choosing judges is a fundamental norm, that this system can be improved and the judges' appointment timelines can be improved. So basically they threw the ball into the government's court. By November 28, Supreme Court told the centre that they should name the names have been pending for 1.5 years. Government is unhappy that NJAC didn't pass constitutional muster. On November 29, the centre returned 20 collegium recommendations to the Supreme Court body. The centre approves appointments of 2 additional judges to Bombay High Court. But by December 7, as I mentioned, Vice President Jagdeep Dhankar said that by scrapping the NJAC, the SC compromised parliamentary sovereignty. December 8, the Supreme Court says collegium is the law of the land. Collegium is to be followed until new system is created. In fact, it went on to say Parliament can enact law, but power to scrutinize lies with the court. And sending names back more than twice is a violation of orders. Remember, as I mentioned, the court has also rejected an RTI plea over collegium meetings now. So why is this such a raging debate? Take a look at the objections against the collegium system, and this is not new. The first and biggest objection is that this is not rooted in the Constitution or any specific law that is promulgated by Parliament. Actually, this system has evolved through judgments of the Supreme Court itself over the years. It is considered non-transparent since it does not involve any official mechanism or a secretariat. It is considered a closed-door affair with no prescribed norms regarding eligibility criteria or even the selection procedure itself. There is no public knowledge of how and when a collegium meets and how it takes its decisions. There are no official meetings minutes of the meetings of the collegium proceedings. And lawyers who are in fray are often themselves in the dark on whether their names have been considered for elevation as a judge or not. And it's not just the government or the legislature. The collegium system has also been questioned from within. Let's take a look. Justice Chalameshwar, who was part of the NJAC case, himself gave a strong dissenting judgment. Here is what he had said. Records absolutely beyond the reach of any person, including the judges of this court, who are not lucky enough to become the Chief Justice of India. He had gone on to say transparency is a vital factor in constitutional governance. Need for transparency is even more important in the appointment of the appointment process. He had also gone on to say proceedings of the collegium were absolutely opaque and inaccessible both to public and history, barring occasional leaks. And more fundamentally, he went on to say to hold that it, which is the government in this case, should be totally excluded from the process would be wholly illogical and inconsistent with the foundations of the theory of democracy. Now, he's not alone. There's Justice A.P. Shah, former Chief Justice of Delhi High Court, who has also criticized the system and the judges themselves for not reforming it. He had gone on to say the collegium system continues to be opaque, secretive and unaccountable. Judges deciding the NJAC case spoke of reforms. What happened to them? There is a very serious question on the Parliament's sovereignty involved here, with the court striking down a law passed by it. But the very collegium system is also a big question of transparency and democracy and accountability, because you don't know what's happening, you don't know whether this system can be corrected, you don't really elect your judges. Compare the two, the collegium and the NJAC. Here's the comparison between the two. Now, the collegium is currently headed by the CJI and 4 senior most judges of the Supreme Court. This is at the Supreme Court level. The NJAC, as it was envisaged, consisted of the CJI, Supreme Court judges, the Law Minister and 2 eminent persons. These were meant to be the Prime Minister and the leader of opposition. So the political system was involved, the legislature was involved. The collegium, no defined procedure or criteria, as I mentioned. The NJAC had clear procedures and discussions among stakeholders. The collegium system, the government only receives names decided by the collegium. Maybe they can send some back and ask for a revision, but really the final word is with the Supreme Court judges themselves. The NJAC, the government and the parliament were part of that decision making. The collective thinking of the legislature basically was part of the decision making. Now, as I mentioned, the collegium is also criticized for lack of transparency, and the NJAC is considered a more collaborative and transparent system, and most importantly, accountable. If things are not good, if things are not liked by the public, the government can be held accountable. Our judges often quote the American democracy and legal precedents in America. They seem to look up to the American judicial system. But you would be surprised to know they don't quite want to follow how US appoints judges. Take a look at how judges are appointed in other big countries. United Kingdom first up. It's a 5-member panel which appoints the judges, which includes the SC president there, the deputy, members of judiciary and bar from England, Scotland and Northern Ireland. In United States, it's actually a very dramatic system. The president appoints the judges to the Supreme Court and the nominations are voted on by the Senate. So it is the politicians who have full control. Germany, the executive and the legislature appoints, and there is an election process to appoint judges. So the big debate that's coming up today in this legislature versus judiciary, where do people stand? What is the right way to go forward? And most importantly, are we heading for a confrontation?
Parliament, in a much-needed historic step, passed the 99th Constitutional Amendment Bill, paving way for the National Judicial Commission. There was unprecedented support. The Lok Sabha unanimously voted in its favor.
Confrontation, which is unfortunately building up, does not augur well for the constitutional scheme, and therefore I had given a notice under Rule 184, an adjournment notice, to have a detailed discussion.
जो कांग्रेस पार्टी और हम में फर्क है ना, कांग्रेस पार्टी जैसा काम करते थे हम वैसे नहीं कर सकते.
Going across to our guest joining us, Anup George Chaudhary is ex-Advocate General, Senior Lawyer in the Supreme Court. Kapil Sankla, Senior Supreme Court Advocate. KK Manan is Chairman Bar Council of Delhi. Advocate Matthew Antony is Advocate and also Congress spokesperson joining us on the show. Let me go across to Mr. Chaudhary first up. Do you believe, Mr. Chaudhary, that what we're witnessing right now is possibly one of the, I don't want to use the word worst, but one of the most serious episodes of confrontations between the Indian parliament system and the judiciary?
Well, I don't know the confrontation part, but the whole question is that this system of collegium has been functioning for several years. No system is perfect. Question is, what to take out the best out of it? Is it so flawed that it should not be done, it should be done away with? Well, it can work both ways. As far as confrontation is concerned, I think the confrontation started with the executive, with our most revered, the Law Minister. I don't know his credentials as a lawyer, but otherwise he's the Law Minister, so it's all right. If he says so, and he's been a big constitutional expert, I suppose, and he knows the Constitution. But apart from that, since the 80s, the collegium system is functioning. Now, and there have been instances, I cannot say that it has been perfect, but so is the executive's way of trying to make things, same way. That system can also be flawed. But remember, the judges who wrote the first judgment of the advocate record case they were all appointed under the old system. The other one who wants this, that the word consultation should be read as concurrence. That's their interpretation. Now, what was the effort? What was the reason? You must say. The reason was to make the judiciary as independent as possible.
But sir, independence cannot mean unaccountability. Now, one of the criticisms of the collegium system is, and I'll come to the question of the law minister, but one of the criticisms of the collegium system is that we all want our judiciary to be independent,
judges are
of course.
accountable to anybody. Sorry, I'm so sorry that.
Sorry?
The moment you start to say accountability, you equate the judges with the executive. That's not correct at all.
So you're saying that the question of accountability does not apply to the judiciary in the same manner as it does to the executive?
You see, question is, when you can't talk of accountability in the same way as you're talking about an accountability of a government servant. Sorry, that's not the way to look at it. Who is accountable? Is the government accountable? And who will who will check the accountability of the government? So both ways it is there. Earlier
but
also,
sir, the government is held accountable by the public.
There used to be a consultation between the governor and the chief minister and the government, and there used to be absolute, harmony in the names which are sent. But there was also a system. Nobody knew about it. You're talking about opaqueness. I still remember in 1972 when Justice J. Swarna was appointed. I was still practicing, a young practitioner of law at that time, and when we entered the courtroom in the morning, we knew Justice J. Swarna had been made the judge. Nobody knew anything about it. But so, what is the need of transparency to this extent that every minute should be recorded and every discussion of the judges? Those judges, supposing they refuse to recommend a particular name, that has to remain with the Supreme Court also. It becomes a question of privacy. Any person will never give his name if his name is bandied around for people to comment. No,
sir. Sir, if I may just come in, I don't think that I'm equating the issue of having accountability with, let's say, RTI being applied to the minutes of the meeting. I think there can be certainly an argument made that whatever goes on in the decision making of the judges need not be in quote-unquote public domain under RTI. But my question about accountability is, the government of the day is held accountable every 5 years. We have a system where we can vote it in or out. Now, one of the criticisms is that you cannot have in one of the pillars of democracy a system where even the government is not part of the consultative process. That's all I'm saying. But I'll take your point forward with Kapil Sankla. Kapil, where do you stand? Because this is an age-old debate. One argument is that just because it's existed for 2 decades or so, it doesn't mean it needs to continue. We need to evolve. The second criticism is that where did the collegium system begin from? It isn't really from our constitution. Should we not relook at it?
See, you're absolutely right, but there are no straight answers. And this is in complete deference to Mr. Manan, who's already spoken very vociferously about it, and I agree with him. Let me put it like this, that as far as what the judges have stated, that the laws can be enacted by the parliament, but they are always under the scrutiny of the judges, and the court is absolutely right. I mean, that is fundamental to our constitution, that the laws can always be enacted, but we are always protected by the judiciary, so that part is right. And like the writ jurisdiction, the protection of our fundamental rights, judicial review is also the soul of the Constitution of India. It's very fundamental to the Constitution of India. As far as those two observations are there, they're absolutely right. But we have to also digress for a moment and see how collegium system really came to be. Because that is what is important, and that is where I believe that this disconnect is happening.
Yeah.
You see, as far as as in the very beginning, till 1950 to 1973, the appointment of the CGI was as per the wishes of the president. The president, it was under the powers of the president. Of course, he had to take in consultation of the CGI and all of that. So the appointment was by the president in consultation with the CGI, and the term consultation is extremely important here.
Yes.
Thereafter came the first judge's case where this issue arose and there was a lot of hullabaloo about it. It is at this time the courts as well as the parliament started distinguishing between what is consultation and what is concurrence. Till this time there was no difficulty. Then the first judge's case in 1982, that is when it was stated by the courts that consultation does not mean concurrence. You see, and this is, and as I said, this is the watershed period, because after that there were lot of cases, there were a lot of questions as far as the powers of the judiciary is concerned and the power of the executive is concerned. And then came the second judge's case in 1993. And it is in this case that for the first time they started talking about the collegium system. So you are absolutely right that this is not fundamental to the constitution. This is emanated from judicial pronouncements. And this is where they said that consultation is equal to concurrence. And this is when the difficulty or the disconnect between the executive and the judiciary did take place. And then of course in the third judge's case in 1998, thereafter, they stated that consultation means that once we have decided, there is no option with the president. He has to send back, he has to give his concurrence to the names, and this is what is being sought to be revisited. I really think that it is important to have a clear divide between the four pillars, and we have to respect all the four pillars. Having said that, openness is something which is very important. Opaqueness is extremely important. You have to understand that difficulties would always arise when people do not have the right to question. And I do not agree with the gentleman before me saying that you cannot question the judiciary. Of course you can question the judiciary. Judiciary opening up. We already have live streaming and people can watch what is happening and what is being argued and how the judges are reacting and the questions that are putting. And there's an immense amount of respect. There was a question 5 years back or 4 years back that no, we cannot have live streaming because judges would ask questions. There would be questions as to the approach of the judges and there would be disrespect of the judiciary. That hasn't happened. We're only loving the fact that you can go on YouTube and you can look at different judges and different lawyers and how laws are coming into place. So I really believe that some kind of understanding has to be struck between these two very important pillars, where there has to be some kind of openness, some kind of clarity. At the same time, we cannot actually encroach upon the powers of the judiciary. That is also extremely important.
Yeah, but the power of the judiciary that we're talking about in this case of appointment of Supreme Court judges was never with the judiciary. That's the point that I'm getting at, Kapil Sankla, that this power was created. It's not really constitutional. Let me bring in KK Manan here, sir. Your views on this. I agree with you. One is, of course, the view that no system is perfect, and I think that's a fair argument. No system is perfect. But in a democracy like India, should the executive not have a say in how and who is appointed at the highest echelons of the judicial system? That's really at the crux of this debate, and especially when the court recently insists that they should be part of the process of the election commissioner, for example. It has to be a give and take.
You see that for the last few years, usually that when this collegium system has begun, it is after 92, 93, I think. For the last more than 20 years, this collegium system is there. But for the last few years, fingers are being raised by the lawyers fraternity as well as public at large, intelligentsia, and even otherwise lot of other things are there. It is absolutely and palpably, I can say, I don't afraid to say that now the collegium system is being questioned. Why this being questioned? Because Bhai Bhatijabad, earlier it was with the executive, now it is in the collegium system. I feel that the collegium system cannot be criticized. We can criticize. Now I was reading in the newspaper that Supreme Court says that the Law Minister should not make such type of statements. Why he can't make these statements? He can. He is the Law Minister of the country. He is in the executive and he is in the government. If something is coming in his knowledge, he has not spoken without having knowledge that few things are not going smoothly in the collegium system. That's why he spoke. So my request before the Honorable Prime Minister now, because it is not good in between judiciary and the government, there should be a conflict. Because if the collegium system is not working, then the government should sit with the CGI and other people who are the at the hem of affairs and sort out this. And if the collegium system requires some amendments, some improvements, then the collegium system and the Supreme Court judges and the CGI should also not feel shy to do it.
No, the
He
one thing
must
is, Mr.
listen
Manan,
the
you've raised a
voice
very
of the
important
public.
question. Absolutely. It's the voice of the public. The government of the day is accountable and the will of the parliament is supreme in India as per constitution. And the question, the point that you raised about criticism
100%.
and question. Now, I'll take that back to Mr. Chaudhary as well. You said, you know, who is the law minister or what qualifications does he have to even question this system? Mr. Chaudhary, the point is exactly this. In India, we're a democracy. We're allowed to at least question and discuss everything. Here, the sense that the public is getting is the court doesn't even want questions and discussion on it. Why not?
You see, the question is that should the law minister, there is not can, I'm saying, should he come out in public? There is a law of the land. Now, the way to overcome that law of the land of a constitution bench is to approach the higher bench, 7 judges bench, if you want a reconsideration. File an application for reconsideration instead of bad-mouthing it in public. That's not correct at all. There are judicial ways out of it. There is a judicial review still there. I'll tell you, TMA Pai's case was first taken by 5 judges, then to 7 judges, went to 9 judges, then it went to 11 judges regarding the rights of the minorities, linguistic and religious, to establish institutions. So there is a way out of it. Now,
but sir, public debate is also
Supreme
very
Court,
important. What
under
happens in
Article
courts is
141,
fine.
a judgment becomes
Mr.
law.
Chaudhary, I'm sorry I'm interrupting you. You know, I'm coming into this discussion as an ordinary citizen. Now, the ordinary citizen is saying that, okay, what happens in courts and how, you know, 5 judge, 7 judge, 9 judge bench is a separate matter. Why can't I discuss it in public? Why can't my law minister say what he's saying and initiate a discussion? Why is the Supreme Court coming down so hardly on it?
All right, do a citizen say that how the CEC and election commissioners are appointed?
Fair
Is
enough.
it file open? Is the RTI available? So let's not talk about that. If everything has to be discussed like that, just because a citizen is saying, which citizen has said that? To a normal citizen, nothing happens. But that matter is also there before the Constitution bench regarding appointment of the election commissioner.
No,
How are you
precisely what I'm
appointed?
saying, sir.
Nobody knows.
What I'm
Within
saying is
24
that
hours, election
I,
commissioner
as
is
a citizen,
appointed. Then
if the
nobody,
law
no
minister
channel
is
has
raising
taken
a
this matter
concern
up.
over the
I think we
present
should take this
system,
matter up.
you know, it's a good thing because a lot of young people in India will learn about this system. They will learn about how this system came into place in the first instance. What are the alternatives available? Why was the NJAC rejected? Let me bring in Advocate Matthew Anthony here as well. You know, the thing that the government seems to be, not just the government of the day, but just generally the political system seems to be concerned about it, and that concern was raised by Vice President Mr. Dhankar also as the chair of Rajya Sabha, is that this law, the NJAC, was passed unanimously by Parliament. It was ratified by as many as 16 states. The fact that it was rejected as unconstitutional is in itself a strike on the sovereignty of Parliament. Don't you think that's the essential argument here? That ultimately the laws are made by the legislature. Yes, the Supreme Court can decide whether a law is infringing on any tenet of the Constitution, but the laws have to be made by Parliament.
So, going by the eminent panelists speaking on the subject, I will try to recall a little bit of history into this conversation. A power to amend is not a power to destroy, is a kind of a principle which was quoted by the Supreme Court in the 1973 Keshavanand Bharati case, where the basic structure of the Constitution was laid out. And in that one, it was clearly mentioned that the basic structure of the Constitution is supreme, and then anything other than that will be considered as unconstitutional. And that's the reason why which the judiciary in 2015 October rejected the NJAC, the bill.
But
So
how
now
is the
coming back
collegium
to this, now we
constitutional? Mr. Matthew, how is the collegium constitutional?
No. Let me come and answer to you on that. The collegium became constitutional with the 3 judges cases, which one was
Exactly.
mentioned here, and the second one was mentioned, and the second one. So, let's go back into the history. The constitution was earlier, the executive was making the decision for the judges, and then from there it became to the judges, with the collegium kind of making the decision of the judges. But I would certainly like to say that, no, let me lay down the principles of this conversation, that we at any point of time, we should think above the party lines, and we should not have a confrontational situation between the judiciary and the executive, because the independence of the judiciary is very, very, very critical for the democracy to sustain and survive. Now, coming back to that, the judiciary has improved the appointment system considerably from the 70s, in the 90s, to a transparent model with the collegium. But then it also developed its own kind of a system of a lack of transparency coming into the picture, which was addressed to a large extent. Now the NJAC, we will see where we disagree with the NJAC thinking right now. We're not completely disagreeing with the NJAC, but we need a certain amount of wider thinking from the executive, because the kind of assertiveness of the absolute majority which the current government, which the current executive having with the legislature, is kind of is like of trying to have the independence of the institution taken out. We have seen that in many institutions right now. So that's the biggest concern which we are raising as a political organization. We are not saying that, no, this is what the Congress party thinks. This is what the BJP. It's not about a partisan politics here. It is about, it's not about me and you here. It is about the generations to come and the people who are living here.
No, fair enough.
That is something,
I'm
so we
actually
need to
not
be
making
wider
this
enough
partisan
to kind
at
of,
all.
that kind of a, yeah. So we
I'm
need
not
to see
making
the
this
wider
partisan at
consequences
all.
of this.
And as I mentioned, the bill, when it first came, was passed unanimously. Mr. Manan, I'm coming back to you. Here is the fundamental thing. If it is about constitutional and unconstitutional, is there not an argument that the collegium system is also not constitutional? It has come from the powers of the judges that have given themselves the power that is now to appoint the judges. It has come through judgments.
Definitely. Definitely. It is not as per the constitution. You have given an example. If we have followed the British constitution by and large, why don't you follow the procedure or the system of UK? And the parliament itself want that, and parliament also want that there should be, some sort of transparency. It is now in a collegium system. I don't say that collegium system totally is bad, but somewhere it requires now improvement and changes in this. For that purpose, the Honorable Prime Minister, Law Minister, and the Honorable Speaker of the Lok Sabha, as well as the Leader of the Opposition, as well as the CGI, they all should sit together and sort it out.
Yeah,
because I say it is not good thing to be, fight on the streets like this in between the judiciary and the executive.
Absolutely.
So
I don't think anybody wants an ugly fight or a back and forth between the judiciary and the executive. That's not good for us.
No, not at all.
Mr. Chaudhary, you wanted to come in?
Yes.
Yes, like K.K. Manan has said, he's given a good suggestion that they must sit and sort this issue out. Whole question now is this, that the government is being seen to completely stifle the collegium's recommendations.
Okay.
They sit on it for months. The collegium has always respected the views of the government. If they have any intelligence source regarding the names recommended, they have communicated to the government in the past, and government has considered them. And those names have been sent back to those people who the government objected to for some reason or the other. But the new formula, modus operandi of this government is, it just sits on the case, just says yes or no. Whereas in one instance, within 48 hours, 5 judges were appointed at a stretch of the Supreme Court. 5 judges within 48 hours. Why this difference at all? They should immediately respond. And if once more the collegium recommends, then they should give respect to the Supreme Court and appoint.
Sir,
or
can I
show
come to the
some reason as to why you don't want a particular person to be a judge.
Fair enough, fair enough.
You just can't
but
sit on it.
exactly in the spirit of this consultative process, is it not fair for the government or the legislature today to say that please come on the same table as us, let's build a different system. The judges cannot be unilaterally appointing themselves. Let's build a system where let's say the law minister, let's say some members of the political parties who are elected members are part of this system. Is that so bad?
That young lady is gone decades now. Let's not go back to that. All this has already gone and over with time and again. When NJAC was struck down by the Constitution bench, it becomes a law. It was struck down because they said it's against the basic structure of the Constitution. Now, you can very well criticize that judgment, but don't demonize it. Effort is on to demonize that judgment.
Can I just say
After
this,
8
please?
years,
Yes,
8 years the
Kapil,
judgment has been enforced. So no, you can criticize, most welcome to criticize. Everybody
So you're saying there is no door, no window open anymore?
Demonize the judgment.
Sir,
We
are
can
you
effort
saying
if
there
we
is
want to
no
demonize the
door,
judgment.
no window open anymore of changing this system?
Well, today the law is there. There is a mode of getting over that 5 Constitution bench judgment is move an application, get it reviewed or get it reconsidered by a larger bench. If the government so feels, why not? If the government felt so strongly that that Constitution bench judgment was wrong, why has it been sitting on it for 8 years and tolerating that judgment?
Okay.
And now coming in after 8 years to say that judgment was bad. I'm sorry, you can't say judgment is bad. You can say judgment is wrong. But if judgment is wrong, there is a process of review.
Or
If
what
review
about
fails,
a new bill altogether? Okay, I'm running.
law way out of it.
Okay,
Not
I'm running
just to
out of time,
demonize
but I
the
want
whole
to give
system
Kapil
and say,
Sankla a word as
it's
well.
not
Yes.
fake, it's all gone on over with.
Kapil also wanted to come in.
Very rarely do I question a fellow panelist, but I have to call out Mr. Chaudhary because he's wrong on many points. He's wrong when he says that this was started by the current government. It wasn't. It was the statement was made by Mr. Dhankar days after the Honorable Supreme Court made a statement saying that the conduct of the executive amounts to willful disobedience, and please resolve this. Don't make us take judicial decision in this regard. So of course the executive had to come back, and they did. Mr. Chaudhary is also wrong on the ground that you cannot question the judiciary, that you cannot openly discuss the judiciary is absolutely wrong. In fact, the current CJI very candidly, very openly stated that it is nice where people question, talk, discuss, and discussions are important. So he's wrong on that ground as well. And also, this was the first time the live streaming of the Supreme Court
Sankla, he is not wrong. Say you don't agree with him.
And lastly, let me say, Mr. Manan, I completely agree with what you're saying, but let me just finish what I was saying. It might be a strong statement. And lastly, I'd also like to say this, that the citizens speak through their elected representatives. And if an elected representative has made a statement, then that also needs to be appreciated as we appreciate any statement made by the Honorable Supreme Court. These are strong words, I do understand, but I could not stop myself from saying this because I was seeing on many grounds that I do not agree with Mr. Chaudhary.
And can I just say, I may be wrong, I'm an ordinary citizen, I'm certainly not a legal mind like all of my very eminent panelists here. Laws change. The Constitution has also changed multiple times.
You're absolutely right, and that's the purpose of laws.
There is absolutely nothing that cannot be
changed. A law that does not
changed.
change is stagnant.
That's all I'm saying. And for anybody to suggest to me that just because something has been said, either in Parliament or in court, we can never relook at it. We can never go back to it. We can never reverse ourselves. I find that very strange. Yes, Mr. Chaudhary, I have final minutes left.
Yes, can reverse. I have not said we can't discuss.
I need a minute.
I think
Sure,
I was
sure.
terribly misinterpreted. No, I've never said that. I said you can discuss,
Yes.
you can criticize. But once the law is made, how do you overcome it? Not by trying to demonize that judgment.
Okay.
You overcome it, file a judicial review, or have a reconsideration done by a larger bench. That's the way to go about it. As long as it stays, the judgment in its form, I'm sorry, the government has to follow it. And
No,
that is why
absolutely. As it stands, it's the law of the land. The Supreme Court is not wrong
unfortunately,
there.
the government is not following it in letter and
In spirit.
Which
Okay.
They should. If they are law abiding, they must follow it. Unless the judgment goes, then stays.
Okay,
So
fair
you may
enough.
criticize
So that's
it.
what I want to come to for our
You may
final comments.
discuss
What's
it.
the way
Most
forward?
certainly you must discuss it.
Mr. Matthew?
Can I speak for a minute?
Yeah, Mr. Matthew, you're part of the opposition. What do you think is the ideal way forward? Because I think from what I get from the Congress party and from, precedent in this case, virtually every party is on the same page that something needs to be done.
I have 2 points to make. One is on your question on whether the constitution or the parliament is supreme. It is undoubtedly the constitution is supreme. Second thing is on the transparency part of it and the selection procedure which is currently in. There can be improvements made into it till the time the government earns the trust of the fact that they will not act in a partisan manner. They will not act with a revenge. They will not act with an intent and motive to appoint and make the institution's reputation, integrity, and independence compromised. Then there will be support from all other parties because we are doing it for the country. In terms of what we can do with the current system is that there can be a dialogue because not all the dialogues need to be in public. There can be confidential, classified conversations, wider consultations between the judiciary and the executive prior to the panel being submitted to the government, in terms of a review process, a selection procedure, then the executive kind of, sends and make the recommendation to the President of India for a warrant and an announcement. There can be improvements made through a consultation in a classified, confidential manner in the existing system itself.
Fundamentally, if an improvement or a change has to be made, what is
Yes,
the way forward
the change
now?
has
Is
to
it
be
the
made.
revision of the old judgment, or can the parliament come together and pass a new law?
So it has to be a multiple wide range of magnanimous consultation like the Constituent Assembly where all stakeholders were involved and everybody's view, even dissenting views were taken into consideration and the consensus was built on how we should take the future of the country forward.
But that's what the government is asking for, that have a consultation or a revision
there is a trust deficit.
The
that is where we
voices
are
that are coming in from the Supreme Court is that no, we decide.
The reason why I as an ordinary citizen and now I know from also from the party perspective, what we are seeing is there is a trust deficit with this government's executive decision making because we are seeing compromises being done on institutions everywhere.
Like, which one?
Like the election commissions, like the bills, the data bill, now the RTI is being diluted, so we see dilutions happening in every office. So the trust has to be built. That is where
I don't have a BJP representative on the show, so unfortunately you cannot be countered. But Mr. Manan, I'll give you the final word. What's the way forward? You broadly seem to believe that there is something that fundamentally needs to change, and absolutely the judiciary and the executive, the legislature have to be on the same page. I don't think one needs to supersede any. And I don't mean to suggest that at all as far as a sensitive issue like the appointment and transfers of judges is concerned. But how do we get to that if it almost becomes a turf war? If it almost becomes a turf war that no, you cannot infringe into our turf, we decide who is the judges going to be, you please stamp those names and do as you say, then how do we get forward? So what do you think can be done?
You see, it's very unfortunate, as I said at the outset. And not only even the Supreme Court or the CGI should intervene. And I think another judge has made the comments and not the CGI. And in fact, CGI is the person who should take the lead and he has to intervene, as well as the Honorable Prime Minister also. It is the duty of both the sides to resolve it amicably. And if there is, a requirement to little bit improve the collegium, if they would like to go as per the collegium and on the collegium system, then it requires definitely some sort of amendment, some sort of transparency, or some sort of, I can say, the interference of the government also.
Yeah, because actually both were together, they balance each other out. What is happening here is we cannot have either just the politicians deciding
up to the
or
mark.
just the
Even
judges
then
deciding.
The Supreme Court says no.
We have to
don't
have
agree.
both of them to
will
balance
have to make
each other.
Him, the judge, we will have to elevate him. This is wrong. I don't agree with that. You see that when the government used to appoint the judges, elevate the judges, they used to go for IB. Lot of people have not become the judges of the high courts whose IB was not good. So now in these days, that thing is totally missing.
Okay.
We do not know why. We have the examples, but I do not want to name them. We were shocked, we were surprised, but I can't name them. But they are now they are elevated. They have been elevated already. They are the judges. But this is unfortunate. So the collegium system, the collegium, the judges who are in collegium, they should also look into that where and why the fingers are being raised on the collegium system. Somewhere some weaknesses are there. For that purpose they have to look into. They can't sit just and say that we are the supreme, whatever we do, it's okay.
It's just
I will remind
exactly.
you,
I think that
when
attitude
the
does not fly
Congress
even if it
government,
comes from
Manmohan Singh
Supreme
government
Court
was there.
judges.
They wanted to increase the age of the Supreme
Mr.
Court
Manan,
and High Court
I don't
judges.
think you can hear
For
me, but
that purpose,
unfortunately
please,
I've run
for
out of
God's sake,
time,
can you
sir. Sir, I've
hear
run out
the
of time.
speech of the leader of the opposition, Arun Jaitley. Arun Jaitley ji made a speech. You kindly hear that speech. What he said on that day and in that speech. Please go through that. So my humble request through your channel, before the Honorable Supreme Court, before the collegium, before the government also, that this fight should not be on the roads. It has come on the roads. Please, for
let's
God's
not
sake,
escalate the fight. Let's find a solution. But something needs to be done. I think that is possibly acceptable to all sides. How it is done is the bone of contention. And that can only really happen through consultation and through consensus. I leave it at that. Gentlemen, thanks a lot for joining us. Time for a very short break. That was the news until now. Let's take a look at some big news that we have for car owners.
Is there in YSR Congress Party? Why they are upright? Why they are every day they are destructing other opposition political party activities? Even Janasena Prachara Ratham, what they are called in vehicle, that is also they are unnecessary. They are creating trouble. If in case of Janasena they are using some colors, especially their defense people, they are using their unnecessary colors. They are using, that is the matter. Will take the transport ministry, transport department, transport officials. Why the YSR Congress Party former minister Nani yesterday they are claiming and they are commenting and criticizing that vehicle. The total this scenario, YSR Congress Party 2024 election, they are not fighting battle in field level. Why? Because it's a lot of corruption and as well as also financial drashti in Andhra Pradesh. Assurance also there, YSR Congress Party there, what they are given in 2019 election promises also, they are not fulfilled. Even unemployment is also high. Today is one of the accidentally, yesterday Parliament they are given the clarification, highest petrol price in our country, one and only state in Andhra Pradesh, second place like you, Telangana like that. Why they are YSR Congress Party, they are not commenting like this one. Even particularly in Andhra Pradesh, YSR Congress Party, day by day they are losing his YSR Congress Party ruling government credibility. 100% upcoming election, BJP Janasena election battle, 100% we are fighting. But once again I will tell to YSR Congress Party government and leaders, don't destroy, don't distract it in opposition political party activities. That is the directly, indirectly a loss in YSR Congress Party, gain in opposition political parties. This is my sincere advice to YSR Congress Party.
All right, now, Mr. Reddy, I do want to ask you a few follow-up questions. Considering that it's not just the YSRCP which is saying that olive green cannot be used, the Additional Transport Commissioner has also said that dark green can only be used for military vehicles. What they're going to attempt to find out is if the vehicle has been bought as a goods vehicle or as a bus. Now, considering that the Additional Transport Commissioner has also said this, do you not think once the clarification does come out about how it's been bought, whether it's a goods vehicle or a bus, let's say that it goes against the vehicle that has been put out as an election campaign vehicle. Now, days after actor turned politician Pawan Kalyan unveiled his campaign vehicle, a special bus which looks similar to a military vehicle, the YSRCP has slammed him, saying that he is violating the Motor Vehicles Act, which states that apart from defense vehicles, no other passenger vehicle can be painted in olive green. Let's listen to some reactions.
Requesting Pawan Kalyan, just come out of the cinema phobia, cinema aura. Indian Motor Vehicle Act, according to Indian Motor Vehicle Act, no one other than army, no one should use olive green color for vehicles, private vehicles. What is there? just to follow the law. Every time you are going to say, I am a law-abiding citizen, I am more, I will respect all the acts, I will respect all the laws. What is there useful by stating statements only?
As far as the Motor Vehicle Act is concerned, the Central Motor Vehicle rules declare that olive green should not be used for any motor vehicle other than the military army vehicles. That is very clear. Second, we have to first see whether this vehicle is bought, the chassis is bought as a goods vehicle or as a passenger vehicle. So we will have to verify all these things, whether this thing can be registered. If so registered, what is the way the owner wants the vehicle to be registered. It cannot be registered as a bus or something. It should be registered as a camper van.
All right, now I'm crossing over to CNN News 18 Swastika Das to get us more. So Swastika, essentially a war of words in Andhra Pradesh. Can you tell us more about Pawan Kalyan's political plans?
Well, Aisha, Pawan Kalyan is set to take a statewide bus yatra and a campaign trail in Andhra Pradesh starting January next year. This is what his tentative proposal is. And he is gearing up for the big elections in Andhra Pradesh in 2024 and also campaigning for the BJP ahead of the Lok Sabha elections. Janasena is in alliance with the Bharatiya Janata Party in Andhra Pradesh, and he has also been making steady effort in stitching an alliance between the TDP, Janasena, as well as the BJP in a bid to bring back TDP into BJP's coalition, NJAC's coalition. And this is something which has now become extremely prominent, with Naidu also making the same overtures to the BJP. But it remains to be seen whether Naidu can come back into NDA's fold. But Pawan Kalyan has been instrumental in doing that. What Pawan Kalyan essentially intends to do is come up with a combined force to take on Jagan Mohan Reddy in Andhra Pradesh. He says Jagan has looted Andhra Pradesh in the name of welfare schemes. The actual beneficiaries are not getting any benefits, and he's on a mission really to go and counter all the false propaganda being put forth by Jagan Mohan Reddy.
All right, Swastika, I want you to stay with us. We are now being joined by Mr. Vishnu Vardhan Reddy of the BJP.
Welcome back. The second installment of Elon Musk's Twitter files has been dropped today on the social media website. It sheds light on the company's practices earlier of secretly blacklisting certain tweets and users, especially conservative voices in the US. The revelations include several images of what appears to be an internal communication system that marked certain accounts as being under various kinds of blacklists, and processes involved were arbitrary at best. The first installment of the Twitter files, remember, exposed how the company suppressed Hunter Biden's laptop story during the 2020 presidential elections. The decision to censor the Hunter Biden story were made at the highest levels at Twitter, but allegedly without the knowledge of its then CEO, Jack Dorsey. So what are the big revelations from this part of the files? It's actually what a lot of people already suspected. Take a look. Employees blacklisted and prevented disfavored tweets from trending. Visibility of, quote, right-wing accounts was limited without informing the users. Twitter stifled Stanford's Dr. Bhattacharya's opinion on COVID lockdowns and especially its impact on children in America. Right-wingers and conservatives were profiled as, quote, do not amplify. Shadow banning process named as visibility filtering, or VF, was used. And this was used to block and limit users' tweets' discoverability, posts, and hashtag. So the big debate that's coming up, it's not really a debate. Frankly, we knew this. Is the truth not finally out? Let's take that to our guests. Aarti Agarwal is author and researcher. Sumansi Raman, political analyst. Anand Mittal is political analyst based in the US. Aarti, I'm coming to you. Frankly, this is not surprising anyone. Are you surprised by what has come out today? And do you have any doubts that this was certainly being done in India too?
Of course. So I think Twitter files is just confirming what we have already known all this time. And I'm personally relieved that the whole world can see it. It's up for everybody to see. There is certain level of transparency now, but what I would want to see is exactly to what extent were Indian, accounts suppressed, and what was the impact on the country, India? Because our constitution supports freedom of speech as well. So to what extent were accounts holding a certain ideology banned or suppressed or suspended? And I mean, we already have our suspicions regarding that as well. But I think that part is also very, very pertinent, and we should ask for that kind of clarification as well about Twitter. So far, the focus has been on American voices and American ideologues, and I understand that Twitter being an American company. But as far as Indian policy is concerned, and Twitter is a very big platform even in India. It has so many users from India, and the fact that Vijaya Gadde and Parag Agarwal were Indian origin people, it makes even more sense for us to ask, like, is there some sort of implicit ideology being pushed in India as well?
No,
So
and the reason
that's a
why
big
that question becomes very important also, Aarti, is because there are a lot of people in India who have complained of either not being given reasons for why their accounts have been suspended, or the arbitrariness in why one tweet is sensitive while the other is not. Suman Sri Raman, in India, people often claim that actually it's the left-wing voices or the quote-unquote right-wing voices who are amplified, the left-wing is suppressed. But actually, you look at a lot of practices that are coming out in the open of these social media giants who have become sovereign nations in themselves. The exact opposite is the truth. Is there any denying that this would have happened in India as well, to quote-unquote right-wing voices or opinions that the likes of Vijay Gadde don't like?
Let's look at the evidence that has come out so far. There are some emails and there are internal communications on the basis of which, it has been said that accounts are being shadow banned and so on. Now, multiple officials from Twitter have clarified that they did resort to de-amplification, but did not actually do any shadow banning. Now, it may be splitting hairs. There may be a thin line between de-amplification and shadow banning. But the point really is, should a platform censor or limit the reach of certain voices? Now, at the end of the day, there are no easy answers. I mean, if there are accounts that are spreading hatred, there are accounts that are calling for violence. Now, should the platform say, look, we are just a platform, we've got nothing to do with this, you please go ahead and you call for violence? I think that is inappropriate as well. So this is not a very simple question that can can be not know at this point of time.
No, I don't think, Suman, anybody is supporting violence or hate speech. Just recently, Kanye West, now goes by the name just Ye, was suspended by Twitter under Elon Musk, who's a free speech absolutist.
But you will. One second. Let me just.
My point is, in this latest files, what has also come out, for example, that a doctor's opinion on COVID lockdowns was considered problematic. Now, who decides in Twitter that he can't voice that opinion?
One second. There are opinions which have to be put through some kind of filters. The point is, who decides? We now know, and even now, I don't think we have been told the full story of what all was filtered. We now, again, Mr. Musk is definitely pro-right-wing, and therefore, he is somebody who is keen on pushing out that right-wing people and right-wing tweets were censored. Now, where left-wing tweets also dealt with in the same way is something we may not know, unless Mr. Musk is going to be fully transparent about it. We don't know how, just like we do not know what the agenda was then of the previous owners of Twitter or those who control Twitter. We now do not know what is Musk's true agenda as well. We know his politics very clearly. He's right-wing, and he wants to make sure that the right-wing voices are not, de-amplified
Anand
anymore.
Mittal,
I'm not sure we know the whole story for us to take a firm
Anand
stand
Mittal,
on.
you are somebody who watches American politics. Now, one of the biggest issues that is arising out of these Twitter files is of how the political narrative was controlled by Twitter at the height of political activity, especially around 2020 elections. The Hunter Biden story, you've got criticisms of COVID, lockdowns or policy in the US or vaccinations in the US, or there are these gatekeepers who have no real qualifications of their own, who decided what is right and wrong and didn't let the public decide if they wanted to believe someone or not. Is this not going to be a major issue in America, given that Americans do value their freedom and their opinion freedom as well? What impact do you think these Twitter files will have?
I think it's going to have a lot of major impact, especially next year as the new Congress is sworn in and the Republicans start to control the House of Representatives. And I think there will be major hearings on this. A lot of executives will be called. A lot of former executives at Twitter will also be called by Congress to testify. I don't know if it's actually going to translate into social media legislation as some Republicans and conservatives want. But I think the real story here really is that it's a story of media collusion. It's reporters in the echo chamber of Twitter, the left-wing reporters, the progressive reporters who are friendly with the Democratic Party. They were lobbying Twitter and other social media companies to do their bidding. And so, for example, what's come out is one of the very prominent accounts called Libs of TikTok that merely reposts videos on their account without putting any perspective on those videos or saying that, you know, this person should be banned or arrested or whatever. Though that account was seen as a very, very, you know, an account that was inciting violence by the reporters. So the media was saying this account is evil, and then they were lobbying Twitter to ban that account. And so what you see in the behind the scenes, the moderation tools, is that the account was indeed it was marked as that it would not be suspended without, you know, executive approval, but yet the account was suspended multiple times. So what that shows is that the people behind the scenes were not even following their own policies. They weren't even following their own rubric for their own metrics for what accounts as hate speech. So Yoel Roth, the executive, was talking to Trust and Safety, was talking to legal, and was saying, well, technically this account doesn't count as hate speech. Yet that account was marked for hate speech, was banned, was shadow banned, not banned, but shadow banned. And so that's the real story here, is that the left, that executives at Twitter, the sort of top people at Twitter, without the knowledge of the CEO, were basically essentially not conspiring, but colluding. So if a reporter on Twitter publicly says this account is evil, then the executives behind the scenes were making moves to make sure that you know, that account was shadow banned, and so that they wouldn't lose credibility.
Sumant, I have 30 seconds, please. 30 seconds.
Yeah, 30 seconds. My simple point on this is, unless you have a comprehensive list of all accounts that face this kind of action, it is extremely difficult to attribute motives to anyone. Now, we know that certain right-wing accounts were banned, and the right-wing is now, having made these discoveries, is now making a big noise about it. Now, where left-wing accounts banned? Is this the full story? Or is there an agenda in selectively saying right-wing accounts were targeted when left-wing accounts may also have faced quote-unquote shadow banning / de-amplification? We don't know at this point of time.
I think you made that point.
So that is
but I think one larger story that is coming out of these Twitter files is that there indeed existed a cozy club of people who all liked each other, didn't like the same set of people, and they did set about to minimizing their voices, and that there were own practices not being followed. The word echo chamber is very correct here that Anand Mittal used. It was amplification of your own ecosystem. As it stands today, that's what we know, Sumant. And it has really, you know, brought to fruition the fears of many people who've had in India too. But we hope, as Sumant is saying, let all the data come out, let all the facets come out. Let's sort this out, because there is a big concern of how social media bodies and companies are behaving. Let's wait and see what happens. I do thank our guests for joining us. With that, it's a wrap on this edition of Plain Speak. The Right Stand is up next.
Good evening. Thanks a lot for staying with us here at CNN News 18. You're watching The Right Stand with me, Ridhima Bhatnagar. The BJP swept Gujarat yesterday with numbers that had never been seen before. 156 out of 182 was the BJP not just breaking its own records, but also numbers that most of us do not remember seeing in decades. The Congress won 17 seats while the Aam Aadmi Party took 5. Before the election, analysts had called this an anti-incumbency election, which could prove problematic for the BJP. Remember, the BJP has been ruling the state for the last 25 years. But the BJP, led by the Prime Minister, took it upon themselves to change that narrative. Remember, the 2017 election hadn't been easy for the BJP. They had been restricted to just 99 out of the total of 182. largely because of the Patidar agitation, the agrarian crisis, demonetization, GST, so on and so forth, which led to the BJP losing a lot of seats in the Saurashtra and the South region. The 2022 win has once again consolidated the fact that the magic of the Prime Minister remains intact. The Prime Minister, remember, campaigned aggressively in the state, hardly leaving any opportunity for opposition parties to make inroads in his home state. For the Congress, it will close 2022 with a handful of problems because it's managed to bag only 17 seats. Remember, a party needs at least 10% strength to send a leader of opposition. So while the BJP has consolidated its position in Gujarat, is Gujarat now proving to be a state with no opposition?
मैंने वादा किया था कि भूपेंद्र नरेंद्र का रिकॉर्ड तोड़े, इसलिए नरेंद्र जी जान से मेहनत करेगा। और गुजरात की जनता ने तो रिकॉर्ड तोड़ने में भी रिकॉर्ड कर दिया, सारे रिकॉर्ड तोड़ दिए।
So what does this saffron surge then mean, not just for the BJP, but for the other political parties as we move towards 2024? One thing is very, very clear. The Prime Minister is an undisputed frontrunner as far as 2024 is concerned. Because what the BJP has now managed to do, it's a formidable, undiminished sway of the Prime Minister as far as his home state is concerned. And it's also important to note that considering the fact the BJP had been in power, there was no sense of callousness on the ground. In fact, it was the opposite that we saw. A 27-year rule of the BJP in Gujarat. And this is what I'm pointing to. There was no fatigue. There was no anti-incumbency. When you spoke to people on the ground, they were said, koi issues hi nahi hai, mudde hi nahi hai. Support for the BJP, for the Prime Minister, it was seen across regions, across castes, across religious groups. But what does this then mean as far as the Congress party and other political parties are concerned? The Congress was decimated. As I said, what about the opposition in the state of Gujarat is a big question mark. The home turf of the Prime Minister has been secured. The BJP has won time and space for the 2024 big battle. But as I said, this is the larger picture. Let's now talk to you about as far as the regions where the BJP managed to make inroads. And I said it was every possible region, caste, every possible calculation that you could get in, the BJP had managed to make inroads. This was the overall picture, 156 out of the 182. It was plus of 57 because last time, remember, they were just reduced to 99. The Congress was reduced to just 17. They lost 60 of what they've seen in 2017. The AAP, which is seen as a relatively new entrant, was just about 5. But now I want to talk to you about the areas where the BJP managed to make a lot of inroads. Let's first begin as far as the Patidar-dominated seats were concerned. Now remember, this was a huge concern as far as the BJP is concerned because in 2017, the Patidar agitation was at its highs. There was agrarian crisis. So because of all of that, the BJP had lost a lot of these seats. But here, just look at it. It's managed to bring all those seats back to that tally. So out of 39, they got 34, which means plus of 12 of what we'd seen in 2017. The Congress got just 2, which means a reduction of about 15. But that's just about as far as the Patidar domination is concerned. If I just show you as far as the tribal domination is concerned, you will see exactly the same picture there as well. So out of 30 seats, the BJP managed to get 26, which means upwards of 14 of what we'd seen in 2017. For the Congress, again, they were just reduced to 3, which means a reduction of almost 12 seats. And this was a picture that we saw in almost every filter that you will see as I move forward. Now let me show you as far as the milk cooperative seats is concerned. This, of course, was again a huge concern. Here again, the BJP got 28 out of the 40 seats, which means upwards of 11. The Congress got just 10, a reduction of 12 seats. What was very interesting to also note here was, there is a certain perception that the Muslims don't vote for the BJP. But just look at those numbers. Out of the 12 Muslim-dominated seats, the BJP got 10 and upwards of 4. The Congress got just 2, which means a reduction of 4. So as I said, every possible filter that you see, as far as the map of Gujarat is concerned, it saw a saffron surge, which means the BJP must have done something right. So over the next 30 minutes, we want to understand what has the BJP done that has ensured that there was no anti-incumbency even after 25 years. We will decode an unprecedented saffron surge. Let me also now bring in our guests. We'll shortly be joined by the political spokespersons of the Congress as well as the BJP. But as of now, I do have the spokesperson of the Aam Aadmi Party, Priyanka Kakkar. We have Rashid Kidwai, author and senior journalist. I also have psephologist of C4, Premchand Palati. Good to have all of you on the broadcast with us. Premchand ji, I'd like to begin the conversation with you as we try and establish a connection with our political representatives as well. When analysts had started analyzing factors, X factors, what could the possible result be, they'd all said that the biggest hurdle for the BJP will be anti-incumbency, because it's almost unimaginable that 25 years